You've reached FITTV. Stick around. We'll be right back. Mediation is a golden opportunity to put aside acrimony and advance the common good when divorce or separation is imminent, or when conflict arises anywhere and disputes must be settled. Today we're delighted to have divorce mediator attorney Sheryl-Anne with us to tell us about her mediation practice and how the mediation choice that she has made was a good one for her. Hi, Sheryl.
Hi, nice to meet you.
Well, tell us how you get started in the business.
Well, I'm a trained litigator to begin with, although when I was in law school, I made it my business to study any subject that was tantamount to ADR or mediation. But back in those days, mediation wasn't anything to speak of. Nobody really knew what it was, and it was going to be a real tough sell getting myself involved and making a living doing mediation.
Thank goodness it is now, by the way,
Thank
right?
God it's come around.
Yeah.
But I decided also, though, to go into litigation in order to get a very good foundation and know the case law and know how to handle myself when I would eventually do mediation. I think that it's very important to have the knowledge, the case law, as to what would happen in court if the mediation did not go as well as the couple wanted, or if they were to go to an attorney and it was an adversarial, what would occur? Because I find that when people come to my office, that is the question in their heads. Well, if I were to go to court, what would I get? And I'm sitting there and I kind of know, you know, you can never have a definitive answer because nothing's definite in court, but you have a good idea.
Yeah. Well, you mean the legal training and the mediation training, and knowing the legal training has helped you, in other words, you're saying?
Absolutely.
Yeah. The only thing I always question about the training is the case law aspect to it. We're a case law state, and that when you identify someone's life, how do you take that life and picture postcard it over to someone else's life? I know that there are comparatives that the legal system has to deal with, but I always found that difficult to do.
Well, absolutely. You're taking one particular scenario and transplanting it into somebody else's family, and who knows if that initial decision even was right for that couple in the first place. Probably wasn't. In my book, it can't be, because the litigation process doesn't take into consideration various emotions and the interests and the needs of the couple and of the children and whatever else there is. It's just, this is the law and this is how it has to be done. And that's why there's so much violation of divorce agreements.
Yeah, the relitigation rate is quite high in the state.
Absolutely, because there's an impartial judge who doesn't know anything about your family, but what the attorneys have told the judge, very impartially, uncompassionately, and making a ruling and decision as to how you're going to live and your children are going to live the rest of their lives. Yeah,
how does anyone else know that but you, the person who's divorcing? I always wondered that myself.
That's right, and I myself have gone through a divorce and custody issues, and so therefore I can really speak from the litigant's perspective, I can speak from the couple's perspective, right, as to what they're going through and how they feel and what questions they're having. I wasn't fortunate enough to have the mediation process available to me. Interesting,
someone had asked me, look at that, when I had told them that I had been divorced. A couple recently said that, I mean, like last week. Oh, look at that, I think that's funny, he's divorced. Oh, I mean, what kind of marriage, I'm thinking in my head what they're talking about. Let's see, what kind of marriage prospect is he if he got divorced, and here he is trying to help us out. But they don't really know that we really aren't doing all that much. The mediation couple is creating this environment for themselves, right?
We're absolutely helping the couple speak to each other so that they can hear each other and not press each other's buttons. I find it fascinating. During the first session, they're both saying what they wanted to say all these years that they never said to each other. They didn't listen to each other. And I can't say manipulate it all, but I help them not press each other's buttons so that they can actually hear each other, and they say, oh, and then a light bulb goes off, and then they start talking that they've never done before. Facilitating
conversation.
Right.
It's not really that, yeah. Do you think that the children benefit from divorcing with a mediator as opposed to divorcing in court with litigation?
Well, there's absolutely no doubt that the children benefit. The children are protected in this process. The parents are going to have to continue parenting forever. If they're at odds and they're not speaking, how do you parent? The child will love both parents. How do you function that way? The litigation process, the adversarial process, pulls the child one way, the other way. It's an impossible situation.
I always find that it's one of the bigger errors in the litigation process in terms of a matrimonial situation, because it is what you say. They're pulling the child away, and they're protecting one side and the other, and there's a winner and a loser suddenly, where before they were all together.
That's right.
Now they can no longer be the same.
Absolutely. And you know what? In the adversarial process, there is no winner. Maybe the attorneys with their fees, but there's no winner. Everybody loses. In mediation, everybody's a winner.
Is it possible, in case that there was a couple that lives, and I know there must be some that find that, and there are some, I've seen some, that want to get out of the process. They can't manage the process. They want to litigate, or they want to beat each other up. So is it easy to withdraw from the mediation process?
They're free to do so at any point in time.
So there's no
mandated order that they adhere and continue with the mediation process. It is a completely voluntary process.
Does a couple give up any rights to either their own rights or to the children's rights in the mediation process?
None whatsoever. None whatsoever. In fact, they may even, you can't talk about rights because it's not rights-based, a mediation process. It's interest-based.
Good phrase, yeah.
We look at, I ask them, what do you need? What are your interests? How do we help you move on with your life? It has nothing to do with rights.
Don't you find some of those couples that come to you are more interested in that, especially if one has departed from the relationship unwantingly, and then they want to attack in some way? They want to know what their rights are to obtain something.
If I find that a couple, or one of the two, is harping on what their rights, I do not act as an attorney, and I do not place blame. I do not say who's right or wrong. What I'll do is say, why don't you both go see an attorney, review your situation, find out what your rights are, then you'll feel more comfortable. Then come back to my office, and we'll sit and we can move past that.
So you asked them to go, did you ever ask them to come into the process, an attorney? They go get an attorney and bring them into the process?
Absolutely.
You do?
Where I see there's an imbalance of power, not abuse, not domestic violence, because that is a no-no. I won't take that couple or continue with a couple. But if I see there's an imbalance, I will suggest very strongly that they seek review from attorneys, some advice, and then they can come back with their attorney in the room if they so wish, or without, whatever they want to do.
And how long would you say the average mediation takes for you and the couples that come to see you? How long would the process take?
You know, I don't think there's really an average. I know it doesn't go on. The longest I ever had was 10 sessions. Most of them would be about, I'd say, 4 or 5, and the last sessions are really having to do with when I put on my neutral but lawyer cap, when I'm actually started drafting the agreement. I don't draft it with them in the room, obviously, but I start compiling the things that need to be put into the agreement. I serve 2 functions. The first one is I mediate the divorce, and then I separately, after everything is, all the agreements have been made, then I put it into an agreement.
It's a memorandum at that point, am I right?
Well, it wouldn't be a memorandum in my, as an attorney, I would put it into a separation agreement, draw up the actual separation agreement as a neutral attorney, and then I then fill out the court documents in order to get the divorce through the court system.
And do you hire, or you don't hire a review attorney?
No.
Or? Okay.
What I do is, once I've drawn up the separation agreement, I give it to each party and I ask them or recommend that they take it to their own attorneys. And I have a panel of attorneys who have been schooled in mediation, as I am, so I review other mediator attorney or mediators' agreements.
Let's talk about what the process looks like for you. I know you've talked about several different issues. Let's put them together in one breath of what is a couple comes to see you in the mediation, they ask for mediation. What do you do with them? You counsel, or you give a free consultation up front and then take it from there?
Well, we've spoken on the phone, so they get a very brief description as to what mediation is, because they're not sure. And then when they come to my office, if they have more questions about the process, I'm happy to tell them what that's all about. And I don't have the clock running the first session at the beginning with those type of questions. And then we start the session, and they'll tell me about their various gripes. And the first session is very much almost like a therapist session. I get to understand the nuances of the relationships, the problems in the relationship, and where they're not communicating and where the issues are, so that I can prevent them from pushing each other's buttons as the process goes along, because it does get contentious, and it does.
It certainly can, yeah.
Yeah.
So then they're in sessions and go from there. How many sessions do they take? And then you're describing what each time you get to see them. It's different each time.
Well, I break up the sessions and I tell them, this next session we're going to be doing custody. And then we deal with the various issues in custody, that's if they're children. And then the following session we're going to do discovery as to the various financial arrangements or information that is needed. Sometimes they have it with them, sometimes they need to get it. If they're pensions, it becomes more complicated, and they need to get valuations. And if there's real estate involved, then that needs to be done as well. And then there might be a break in time, because we need to get those valuations done. And then they'll come back a couple months later or 3 weeks later. And then I meet and we discuss that. Sometimes they would like, and I recommend that they bring an accountant or financial planner.
To call in a forensic evaluator of some kind, if necessary.
An accountant who is schooled, again, in mediation, and there are different organizations that have that. They're trained financial planners, not only to see what their financial situation is currently, but to help both of them plan for the future.
So let's say that you were trying to draw a picture for the audience seeing you now, and they want to hire you in their minds. People are looking at the film and they're saying, who are you? What is it that you have in your mind about mediation? How would you describe to somebody who doesn't know about the process and maybe someday and may want to remember what you've said? How would you describe the benefits and elaborate, take your time.
I analogize mediation to a couple fighting over, let's take an orange, and I want the orange, I want the orange, no, I want the orange. By the end, the orange is totally squished up and nobody gets anything. And that could be the money, that could be the children, but that's it. However, during mediation, I would say to them, well, why do you want the orange? Why do you want the orange? Well, I want the orange because I like the juice every day, and I need the whole orange to give me the amount of juice I need. And I want the orange because I bake, I have a business, and I bake, and I need the rind. So I say to them, well, why don't we just peel the orange? And I know it's simplistic, but look at the two different situations. The litigants are saying, I'm entitled to it, and I want it, and I need it. This way, they're happy.
So they get a chance to maybe take apart their own psychology about something, their own thought process, or the workings of their own mind. They get to stop it, having to listen to the analogy that you drew, which works for me. I'm sold. Right. So you want to know what is it that person's saying? They're saying something that's giving them an option to look at something they previously had been locked down about, and maybe open the door for possibility of change, right?
Right. It opens up their mind to think of the different possibilities instead of just give it all to me.
And beating each other up over it. Okay, I'm going to go through this segment here with, from this point on, talking about the comparisons between the litigation process and some of the results and how it compares to the mediation process. So, I just want your comments about them if you can.
Okay.
If you want to pass on it, you can pass on it. But this is how the adversarial process works in this area. Couples abdicate decision-making to a lawyer or a judge, whereas in mediation, the couples take responsibility of their own decisions.
The significance of that statement is that a judge will make a ruling and the couple has to live by that ruling. If they don't like it, they have to go back to court, or there are violations and the one has to chase the other, and it can go on and on and on. With children involved, it's constant tension, it's constant trouble, and money wasted that could have been given to the children. In the mediation process, the couple themselves craft the agreement together, therefore the compliance with the agreement is far more likely, and therefore a happier result.
Yeah, the compliance level going up when you've created it yourself.
Correct.
Yes. The communication is a big issue, and in the court system, you're even advised by your attorneys when you quote unquote protected, I hate to use that word, not to communicate with the other half, whereas in mediation, it's the basis for making decisions.
Correct.
So where's the value of?
It's the broken telephone effect with the adversarial process. You are told, do not speak to each other. So what happens? You tell your attorney, or maybe you tell the attorney's secretary first, who passes on the message to the attorney. Then that attorney tells the other attorney, or maybe the other attorney's paralegal that goes to the attorney, and by the end, you know what happens. It's a game.
Sure.
The correct message was not transferred, and then of course the person on the other end says, what? That? And then they shoot back with something completely ridiculous.
And now, of course, they're upset about it and runs up more billable hours or whatever the
Correct.
case may be. It goes on forever. I love the term broken telephone effect. Settlements are let's pass the judge. We went through that. You answered that question. There's a lack of commitment. You also answered that one too, because a lack of commitment to the decision, and when a judge is doing it, whereas in mediations, you're making it yourself. Let's talk about the children suffering adverse effects of the battles between the parents in the litigation process, the children's effects. And the children is a prime focus of mediation. And good parental relationships are fostered in mediation.
I would say, I'm not a psychologist, but throughout the adversarial process, the children are really yanked from one end to the other, and they have to, at a young age, have a law guardian, attorney for the child, it's now called, and they have this attorney. I mean, they suddenly have to grow up a million years when they just want to be left to be kids and love mom and dad. And who knows what effect that has on future relationships.
Sure.
That they, who knows? But I can say this, that in mediation that does not occur.
The children being used as a pawn in that regard, as a weapon from one parent to the other, whereas the structure is prevented from doing that in mediation, where we're using the focus, right, of children, actually more of a focus.
Correct.
They're not used as a weapon, they're used as, they're not used at all.
I tend to constantly bring the couple back to what's important to them. It's the children, to make them, to bring them together, rather than something to bring them apart. In the adversarial system, they use the kids actually to bring them further apart. They use them as pawns. It's a game, it's a chess game. This is not a chess game at all.
By a long shot, especially when it comes to your family. New negotiation, communications, and problem-solving skills are learned. There's no new stuff learned in a litigation process, whereas this problem-solving is sometimes a learned event in a mediation process. They begin to work together where previously they were not able to.
Correct. The sky's the limit in terms of interesting, creative ways to solve a problem. In the court system, it is fixed, it's within a box, and not appropriate 90% of the time. Mediation, it's whatever the couple can fashion between them based on their own thoughts, needs, interests, and their children's interests.
Perfectly answered. There's an unknown length of time for the process. The potential for a long fight goes on forever in the litigation process. We've known plenty of people that have been in it for 8, 10 years.
Absolutely.
The structured sessions, planned agenda, and established time frame for reaching an agreement are a little bit more of the mediation process, right?
Are they a little bit?
Well, they're more evident in the mediation process. You can.
Well, it's very simple in the mediation
That's what I'm saying.
process.
It's simple. You don't have to go very complicated. I'm sorry.
No, you have the mediation sessions. I draw up the agreement. I draw up the divorce documents. They go through the court system, and you can have a divorce in 3-4 months.
Right, and is that about average for you? You know, the
It
clients?
depends. I
Yeah.
really don't like to do averages. I had a couple where there was a huge amount of money involved. It was already a 2-year litigation. Each member of the couple had spent, one was $70,000, the other was $60,000. Their name was around the community. They were at odds. They were fighting like crazy. It took me about 7 to 10 sessions with them to get everything done.
Sure.
But they had litigated for 2 years, and it took me, 1.5, 2 months to get everything done, soup to nuts, and then I submitted the papers.
Yeah, I have the pride of mediating a couple for 45 minutes, and they had been in court for 2.5 years, and each of them had spent $100,000.
Yeah.
In 45 minutes, it was over. Somebody had to sit there and listen. And the system, litigation system, doesn't have that
It does
as
not.
part of its process. The only other thing is extreme cost. The only last item I want to talk to you about is a big cost factor.
Well, it's a
differential.
joke. Mediation, the cost of mediation is a joke compared to the adversarial process. There's no retainer for the actual mediation sessions. It's like a therapist's office. It's more expensive than a therapist's office, granted, but it's like a therapist's office. You pay as you go. And the only fee I take up front is before I draft the agreement, and it's an eighth, well, far less. I can't even put a number on how much less it is than the adversarial process.
You know, how would you average out? You don't like the word average, so I'm going to stop using the word average. What I mean is what would you like the public to know regarding the differences between the two if you had to come up with some blanket thing? We just went through so many specifics, so I'm somewhere in the middle as an answer of they will benefit in an overall sense somehow. So how would you try to describe that? The benefits to mediation in a summation sort of way.
The benefits to mediation are that you can craft your own agreement according to your own needs and your own interests, and according to your spouse's needs and interests and your children's needs and interests. But in the adversarial process, that is not taken into consideration whatsoever. And that's really the bottom line.
Mm-hmm. Sheryl-Anne Sesto, thank you very much. I appreciate that. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every week. Of course, we always invite all opposing views. My name is Chris DiMaggio, and thank you very much for watching FIT TV, and we'll see you again next week.